Hi, I'm firearms attorney Gilbert Ambler, and today we are going to talk about why short-barreled rifles should be removed from the National Firearms Act based on the fact that they are in common use. And this is doubly true when we factor in all of those recent braced pistols turned SBRs by the ATF's new rule. Before we dive into this, if you have not yet hit that subscribe button, go ahead, hit subscribe. Like this, share this, tell your friends. That way you and your friends can keep getting this important Second Amendment related content. Now, when I say common use, we are talking about a test that the Supreme Court has laid out for what types of arms get Second Amendment protection. And this has been a changing test over the years. When we look back at older cases, like the Miller case from 1939, we see that the focus of the Miller case was whether the weapon was useful for militia service, okay? And that is, we contend, still relevant to the analysis, but with more modern cases has come the focus on whether the weapon is in common use for a lawful purpose, okay? Whether it is a bearable arm in common use for a lawful purpose, and if it is, then it deserves Second Amendment protection. Now, I do want to point out that anti-gun lawyers have been arguing that this test needs to be narrowed down, and some courts have been accepting this argument that the test should be narrowed down to whether it is in common use for self-defense. Now, we contend that that is far too narrow an analysis, because the question is not, is it in common use for self-defense? The question is it in common use for a lawful purpose? And when we use that analysis, what we find is that short-barreled rifles absolutely should meet that test. And they should meet that test for a couple of reasons. First, let's talk about the number of short-barreled rifles in this country. And we're going to limit this to registered short-barreled rifles, okay? We're going to forget about all of the brace pistols that people did not register. We're limiting this to registered short-barreled rifles. Before the ATF's pistol brace rule, roughly 500,000, roughly 530,000 registered SBRs in this country. After the pistol brace rule, the ATF says that there were roughly 250,000 applications that they received to register braced pistols as SBRs. So that takes the number from 500,000 to 750,000, 750,000 registered short-barreled rifles in this country. Now, when we ask how many short-barreled rifles are used in crimes, we find a very, very low number. In fact, in the final rule, the ATF could point to only 2 instances where a braced pistol, which they called an SBR, was used in criminal activity. Okay, so overwhelmingly, these things are legally owned, legally possessed, and not used for crime. So in common use for a lawful purpose. Now, why do we say they're in common use? Well, there's case law on our side in this respect, because in Castellano versus Massachusetts, the court addressed stun guns and found that there were hundreds of thousands of stun guns, of course, being bearable arms. And they said that hundreds of thousands of stun guns showed they were in common use for a lawful purpose. An Eastern District Court in New York looked at nunchucks and found that there was a number of between 60 and 70,000 nunchucks in existence, and said that 60 to 70,000 showed that nunchucks were in common use for a lawful purpose. So clearly, when we get up to 750,000, these are items that are in common use for a lawful purpose. Now, I do want to bring back one additional point, which is I talked about how anti-gunners were trying to narrow this test and say the test, or the appropriate test, is in common use for lawful purpose of self-defense. And we would contend, and so what they would do is they would say you can't find all that many examples of SBRs being used for self-defense. The counterpoint to that is, even if a judge were to accept the argument that the analysis should be whether these are being used for lawful self-defense, which again we think is too narrow, but if a judge accepts that argument, I would contend that these SBRs are still possessed for self-defense, that the trigger does not have to be pulled on a weapon in order for it to be a self-defense weapon. Meaning, me just having the weapon in my home, having the ability to access it, works as a deterrent if someone decides they're going to break into my home. I might never have to discharge the weapon in order to stop that threat. So we might not even get that into a self-defense shooting analysis, because I might stop the threat short of a shooting. So I would say that it is an unfair analysis when they conduct that analysis, and what they're looking at is how many SBRs are used in self-defense shootings. We need to look at whether these weapons are used as a deterrent for home defense as well. So That's sort of a bit of a aside as to what we're talking about here, but I do want to note that because that's going to likely be a factor in some cases in some districts. Clearly, I believe that SBRs are in lawful use, in common use for a lawful purpose, and therefore I believe they deserve Second Amendment protection and should be removed from the National Firearms Act. I also think it is unlikely to happen, at least based on the current lawsuits. And the reason I think it's unlikely to happen based on the current lawsuits pending involving the pistol brace rule, although some of these lawsuits have made this argument, is because I believe judges are going to use constitutional avoidance to avoid answering this question. Meaning, if they can find the pistol brace rule unconstitutional on other grounds, such as statutory grounds or Administrative Procedure Act grounds, then they do not have to reach the issue of the Second Amendment as it relates to the NFA. And if they can avoid answering that question, there is a judicial principle known as constitutional avoidance that says that is what they should do. And the reason we have constitutional avoidance is to avoid there always being groundbreaking constitutional changes every time an issue like this pops up. They would rather decide these issues on statutory grounds than revert to the Constitution. I expect that is what is going to happen here. Nonetheless, if they were to reach the issue of whether short-barreled rifles are protected by the Second Amendment, I think the answer, with 750,000 of them in existence, is irrefutably yes. If you enjoyed this content, please go ahead, hit that like button, subscribe, share this. Until next time.